Hi, everyone. Brian Vicente here. Welcome to this super exciting, historic webinar. We're going to give people just a minute or so to take their seats, but we have simply wonderful programming today. Really thrilled to be joined by our friends at NORML, our friends at MPP, our friends at KKB, the sort of FDA law firm, and then, of course, a bunch of my partners here at Vicente. Um, Ton to cover. We're going to do our best to issue spot many of the exciting pieces that came out from the order and the sort of memos related to that last week from the federal government. Incredibly timely, incredibly important. 2 minutes in, I'll give just a quick kind of intro right now, and then we'll turn it right over to the panelists. But I think folks know our law firm's been very involved in rescheduling. We started working with the Biden administration, then the Trump administration. We were one of the petitioners, the administrative hearing, which the DEA put forward. We helped coordinate thousands of comments around this, pushing for Schedule 3 or beyond. And we also provided a lot of the underpinning framework on the treaty issue, which helped frame the discussion and frame the order that came out from the federal government. So we're really thrilled to have played a role. Before we really jump into the kind of ins and outs of this and the business side, I do want to say, just as a long-term patient advocate, I started doing this work about 20 years ago, representing people dying of cancer and AIDS and people being jailed for medical marijuana, people not being able to get transplants as patients, people being kicked out of public housing, losing rights to their kids. Incredibly gratifying win for medical marijuana patients, their doctors and providers last week for the federal government for the first time in 50 years to acknowledge formally the medical value of cannabis. So it's not the end game, but it is a big, big step forward. So a number of pieces here that we're going to pound through. Certainly the rescheduling order and its effective date and the 280E implications on medical cannabis businesses there. We're also going to talk about the application to the DEA, which is going to be due in about 60 days. Breaking news, that form is actually available to apply for medical licensed businesses as of about an hour ago. Our firm has done these applications before to the federal government, not for cannabis, but for psychedelics and others successfully. We're going to work with our friends at KKB that we've been working with for 14 years on drug applications and so forth to get these done. So if you need help with that application, we're happy to help. And then we're also going to talk through the administrative hearing because this is not done yet, right? Starting in I think it's late June, we're going to see an administrative hearing to potentially move all of cannabis to Schedule 3 instead of simply medical cannabis. So truly, truly exciting. With that, let's go to the next slide, and then I'm going to turn things over here's our beautiful panelist. I will say is a little bit of a Mount Rushmore of cannabis, having Paul Armentano on from NORML, having my good friend Adam Smith from Marijuana Policy Project. So many people contributed to the order last week, but the groundwork from that was laid for decades and decades of work by NORML, by MPP, by other advocates. So I really am excited to hear what they have to say. So with that, I'm going to turn things over to really jump through the last week's order. That's going to be my partner, Sean Hauser, as well as Samantha Hong. Sean?
Thanks, Brian. And I would just echo what Brian said. This, did not all happen by, accident or happenstance. It's in, no small part to the work of a lot of people on this webinar and in the industry, and including patients and doctors who have, operated in this space and a risk-based federally illegal framework and are moving into a new era of legitimacy and access. So really excited to be here and grateful for the industry and community that's all contributed to get here. And I'm Sean Hauser. I'm one of the partners here at Vicente and also lead our federal policy work. And I'm going to break down the order here, which is a tall task, but we're going to kind of hit the high points. And I'm really pleased to be joined by my colleague Samantha from Kleinfeld Kaplan and Becker. As Brian mentioned, we've had a wonderful strategic partnership over the last 14 years. And Samantha, I'll let you introduce yourself and share a little bit about the firm's work with FDA and DEA.
Great. Can you all hear me?
Yes.
I'm Samantha Hong. I'm a partner at Kleinfeld Kaplan and Becker. As Sean mentioned, we have been working with Vicente for quite some time, including on these rescheduling issues. We are a food and drug law boutique law firm in Washington, D.C., and focus a lot on FDA-regulated products, of which marijuana and cannabis arguably are included. And I previously worked at the FDA in the Chief Counsel's office doing civil enforcement matters. So we've worked closely with DOJ as well, and I'm happy to be a part of this webinar with this group.
Thank you. No, and we're excited to be in an era where we're now, collaborating with or working with DEA and FDA as federal regulatory agencies. And, breaking down the order, we were pleased to see that the Department of Justice relied in part on the international treaties, specifically 21 USC 811 D1, commonly known and referred to by us as the treaty exception, which allowed the government to reschedule without delay or disturbance to the process. And that provision authorizes the Attorney General to essentially bypass notice and rulemaking under the APA and issue a direct order if he thinks it's the most appropriate schedule to carry out our obligations under international treaties, including the single convention. And those obligations include promoting the public health and welfare, at the as a priority, which certainly favors regulation rather than prohibition. And the harms of prohibition and the detriments on society are very clear. So I think that fundamental treaty component is very strong, legally and substantively, and also to appropriately regulate cannabis for medical and scientific purposes. So we'll have a whole section here unpacking what that means from a DEA regulatory perspective with Samantha. But essentially, what the Attorney General did here is ensured that placing marijuana in Schedule 3, one was in furtherance of the treaty and its obligations. We've seen other countries do this, but also to maintain compliance with the single convention. So you'll see that the final order supplements the scheduling change with specific regulatory controls, import-export permits, inventory controls that DEA-registered medical cannabis businesses will have to apply to or have to comply with. And so does this mean medical marijuana is now legal? It is now legal as a Schedule 3 regulated substance, legally under the Controlled Substances Act, as long as a company has the appropriate state medical licensure. And for companies to be lawful Schedule 3 registrants with the DEA, they're going to have to meet the DEA registration requirements and comply with those specific registration and compliance requirements, which we'll unpack. So it's if you are a medical licensee, you're now operating with a Schedule 3 substance, and this will immediately unlock the removal of the 280E penalty and allow you to be open to the DEA registration pathway. It allows sort of this expedited pathway, allowing a business to use its compliant state medical marijuana license as evidence of compliance. But notably, the order states that any form of marijuana that is subject to a state medical marijuana license or as an FDA-approved drug product to be officially classified as a Schedule 3 controlled substance. So you don't technically need a DEA registration for the product itself to meet the definition of Schedule 3. And we'll walk through, kind of the pros and cons of DEA registration. But to lawfully manufacture, distribute, or dispense under the Controlled Substances Act, the operator must be registered with the DEA, and state licensure alone would not be adequate to authorize the transactions between the closed loop, because the DEA licensees will have to only operate within their closed loop system. So the final order created a new expedited pathway for state medical marijuana businesses to apply for and obtain that registration. And like I said, we'll run through the pros and cons. And Samantha, can you give a few notes just from a practical perspective, what that means for medical marijuana businesses? Will they need, as far as having pharmacists, what it means for licensed dispensing?
Yeah. So I guess I'll jump in, put my FDA hat on for just a brief second, and note that the DEA this scheduling does not technically impact the legality of these products under the Federal Food, Drug, and Cosmetic Act. State licensed medical marijuana, because it is intended for use for medical purposes, is considered a drug and would be treated as such by the FDA. But it to date, FDA has never approved a new drug application for drugs containing botanical marijuana. But FDA has not generally taken any enforcement action against these products in its history. And with rescheduling, FDA arguably has even more of a compelling reason to maintain its current enforcement priorities with respect to these activities. And it would be quite the about-face for DEA to have issued this new scheduling order and for FDA to shift gears and start enforcement. So that FDA piece, I think we should keep lingering in the back of our minds. Insofar as pharmacies, so it's important to highlight that for controlled substances generally, DEA requires that they only be dispensed pursuant to a prescription issued by a licensed practitioner, and that would include whatever you see in your normal prescription, dosage strength, form, directions for use, etc. But the final rule states that these requirements don't apply in the context of a state licensed medical marijuana. Instead, we can talk more about this when we get to the registration piece, but DEA really defers to state requirements. So if a state law authorizes use of a certification, for example, in a particular state, including self-certification, that you need medical marijuana for whatever medical condition you might have. If that would be sufficient for users to obtain marijuana, then this would be sufficient from DEA's perspective as well, irrespective of the overarching DEA requirement that traditional prescriptions are required for other controlled substances. And in this construct, DEA states that dispensaries would register as practitioners in the same way that traditional pharmacies would, because they transfer these products to the ultimate end user. And so that might arguably be interpreted to mean that everyone can operate in existence with status quo so long as they're state legal and register with DEA per the requirements that we'll talk about later. And it's also possible that traditional DEA registered pharmacies may be able to dispense state licensed medical marijuana pursuant to a state authorized certification that is consistent with state law without jeopardizing their existing DEA registration. So that's a possible pathway that might exist as well.
Thank you. No, each of these breakdown topics could be their own webinar, so we'll continue to break these things down in future sections as well. And I think important to note, there's a lot of good questions in the chat on interstate commerce, which I'll get to in a minute. But what is and isn't rescheduled? Notably, the order just reschedules natural Delta 9 THC if it's subject to a state medical marijuana license or if it's contained in an FDA-approved drug. That means no synthetic and no adult use at this time, but there is an expedited hearing pathway to address non-medical cannabis. And there's also a number of implications for research, which we will unpack. And because the reclassification is strictly tethered to the medical marijuana license, adult use cannabis falls outside of it. But this becomes very complicated, as many of you know, in states with these hybrid licenses, like many of the mature marijuana states, Nevada, Oregon, Washington, and in states like Washington, Colorado, where so much of the industry is adult use. So there's not current guidance in the order with respect to inventory segregation or liability of these dual licenses with respect to DEA and treaty compliance and with respect to the tax implications. But we can glean a lot from it, understanding what's going to be required for DEA and treaty compliance and to ensure the accounting for taxes properly segregated. So that's going to be a key piece to unpack as an industry, and one where I think industry engagement on guidance is going to need to be a priority. And Samantha, any thoughts there on kind of best practices for folks with these unique hybrid licenses?
Yeah, we can talk maybe more about this in the registration section as well, but again, sort of from an FDA perspective, a a substance is regulated based on its intended use. So here we're talking about marijuana used for medical purposes, and FDA again would regulate that as an unapproved new drug. Whether FDA would enforce against that, again, that seems highly unlikely. I don't think that rescheduling really has any bearing on what FDA may or may not do, and the hybrid licenses is not a mechanism that sort of means anything insofar as the status of the drug under the Federal Food, Drug, and Cosmetic Act. It would be odd for FDA to issue a blanket approval for medical marijuana based on state licensed operations. So I think when we talk about registration from a DEA perspective, that would be sort of wholly separate and apart from the regulatory status of these products. I'm not sure if that's what you were getting at, Sean, for the dual license piece.
No, that's helpful. Yeah, and I think when folks look at the state and federal compliance pieces, it will inform, what will need to be separated if there are kind of these dual use licenses. But that's, really something I think the industry is going to need to continue to unpack and also focus on for the upcoming hearing. And then, it's possible there's kind of two universes here of medical operators. I think those that may register with the DEA and those that may not, and two systems. The ones that register with the DEA would engage in activity amongst each other potentially. And then there may be another kind of parallel system of those who don't register with the DEA. And I think there's, businesses are considering pros and cons to the registration. So I know that's something, Samantha, you'll talk further about in the registration section. And then, the interstate commerce question is also one that I think everyone's looking at closely, especially in consideration of these licenses, these dual licenses, and the FDA's longstanding and public safety focus, not enforcement policy with respect to cannabis. The final order focuses on reclassification and registration and setting up this federally regulated system, but it does not create any federal permit to ship across state lines. And even though, we will have DEA registered licenses, interstate commerce requires FDA legality. But we have seen, over the years, the industry has historically relied on enforcement discretion, suggesting and, going on for over a decade with state regulated cannabis businesses and hemp businesses, that they're hands off unless a company makes egregious drug claims or creates a severe public health crisis. So to your point, Samantha, it seems highly unlikely that the administration would facilitate a Schedule III registration only to direct the FDA to shut down those same entities. But would they, extend their kind of hands-off approach to interstate commerce now that this is medical cannabis in a DEA registered system? And also state law very much matters here. There's a number of, and state compliance matters significantly, especially when you have a DEA registration at hand, and a number of state laws prohibit in their laws interstate commerce. So that will be relevant too. And then, of course, state level import export bans, are going to raise the constitutional question under the Dormant Commerce Clause, and whether, federal legality under the FDA could justify trade barriers. So a lot of good questions on the interstate commerce piece. And Samantha, if you have anything to add there, I know it's
I just wanted to jump in to your point, Sean, about the DEA registration in this context is limited to the, it's subject to the limitations of the state license. So to the extent the state license prohibits interstate commerce, that's an obstacle that will need to be addressed. And with respect to the FDA, federal interstate commerce, FDA's jurisdictional hook is typically in the context of interstate commerce, and I understand these state operators have been sort of operating within state lines, but FDA has really extended the scope of the reach of its interstate hook in broad ways. So, for example, if the packaging for your product travels in interstate commerce, in theory, FDA could go after you. So it's chosen not to, obviously, with respect to its enforcement discretion against these products. And I don't think that increased interstate scope of the travel of these products is going to change FDA priorities, unless, as Sean said, there is some sort of public health issue, some safety issue arises as a result of this new scheme.
Thank you. Yeah, and I think the same considerations apply to international trade. The international trade of state licensed medical marijuana and FDA-approved products is tightly controlled under the DEA regulations and import and export permits. And then, there's federal CGMP certification and compliance with countries of exports. But, the practical barriers with FDA on import and export, kind of remain subject to, whether they're going to apply similar enforcement-based approaches to cannabis as they have historically with hemp and other, non-FDA approved substances, and whether that will be different with medical cannabis and Schedule III. So, some more to unpack around international trade. And I know I'm over time here, so I'll turn it over to Adam Fine and Paul Armentano to unpack the administrative hearing. And I'll note that I know I didn't hit important things like taxes, but there's a whole section for that, so don't worry. Adam and Paul.
Great. Thank you, Sean. Yeah, so I think I'll try and make up some time here, go quickly, but we're back on for the full hearing, and as everyone knows, the Controlled Substance Act does require formal rulemaking, unless you're in the treaty realm exception. So the good news is that unlike the prior iteration of the formal rulemaking, which was protracted and paused and contentious, the order makes pretty clear that they're kind of going to set a pretty expedited, especially in the context of formal rulemaking, which historically can take years. Here, they've set a really kind of a pretty precise timeline. So let me just go through that quickly, and then Paul will have more to add about historical context with respect to these hearings. But big date to be aware of, June 29th is at 9 a.m. The hearing is going to start. It's going to finish up by the July 15th. And with a small break over the July 4th weekend. And then in terms of participation in the hearing, you have to be under under formal rulemaking rules, you have to be an interested party. That really kind of means if you want to participate, you have to submit there'll be a way to do that and submit online. I don't have the email address, Paul, maybe you have that, but by May 24th, that needs to be submitted. And then you'll need to basically be to be an interested person, you're actually an adverse party. So you're gonna have to say in some way or articulate in some way why the rule is going to kind of adversely affect you. And there's a whole nother discussion on how you do that. Obviously, if you're an adult use operator only, or it's harder. But if you're medical and adult use, that's kind of the way to talk about how the rule could potentially impact you negatively, even though you may go in and want to speak, and you should hopefully go in and speak in favor of the rule. This probably goes without saying, but the DEA has the burden here. It's really, really important in these formal rulemaking hearings to establish a really clean, a robust record. And that's really going to be, it was a concern last time around. The hope this time around is that the DEA will be in the position to create a really good record. But the more interested persons that are participating, that are in favor of rescheduling to Schedule III, that can provide expert or any type of testimony, we really, really want that. So hopefully there'll be a good outreach of interested people that can get in, and the DEA will be selecting those parties, those interested persons, by June 22nd, 2026. So that'll be just before the hearing. if everything goes to plan, I think people could expect a final rule if it met their burden by the end of the year. So with that, Paul, I'll hand it off to you to fill in the gaps of anything I may have missed that you
Yeah,
want to add.
thank you, Adam. And thank you, Brian, and everyone else at the Vincente Group for having me on board on this important webinar. I'm the Deputy Director for NORML, the National Organization for Reform of Marijuana Laws, and I've been advocating in this space for 30 plus years. And this is certainly a historic change in federal cannabis policy. Um, to echo what Adam said, yes, there will be administrative law hearings before the DEA beginning on June 29th. Now, as many folks are listening already, I'm sure know, there were supposed to be hearings in January of 2025, and those hearings never took place. The reason those hearings never took place is because the judge in that case issued a stay in those hearings. There were concerns going into those hearings that some of the parties involved in those hearings were speaking out of school with the DEA, and some participants were concerned they were not going to get a fair shake at that hearing. And ultimately, the judge in that case agreed and ordered a stay. That's why those hearings never took place. Those hearings have now been terminated, and a new set of hearings are going to begin on June 29th. Like Adam said, the participants in these hearings are going to have to apply with DEA. They are going to have to make the case to DEA that they are aggrieved by this rule in order to be able to participate in the hearing. Even if folks had applied and were confirmed to be participants in the prior set of hearings in January 2025, they need to reapply if they want to participate in these particular hearings. The judge in the previous case has resigned, and Todd Blanche, in his order, said that he will designate a new judge to oversee these hearings when they take place in late June and in early July. The purpose of these hearings are to deliberate over the initial proposed rescheduling rule. And that's a point I really want to stress to folks. The order that came out on Thursday, as was previously discussed, was very narrow in its focus. It only talked about rescheduling state authorized medical cannabis. The actual proposed rulemaking that goes back to 2023 did not make that distinction. It talked about rescheduling botanical cannabis from Schedule 1 to Schedule 3. The ruling on Thursday did not follow through on that recommendation. That is what the ALJ hearing is going to discuss. It is going to deliberate over that more comprehensive recommendation, which would be moving botanical cannabis from 1 to 3, not just state authorized medical cannabis. The final thing I want to say with respect to timeline, I know there's a lot of folks hoping that this happens very expeditiously. I'm sure there were plenty of folks that ahead of the 2025 scheduled hearings were hoping that that would be an expeditious process. And as we've learned, that wasn't the case. Those hearings were delayed and then they never took place at all. Hopefully, we're not going to see some sort of similar delay in these particular hearings. But when we look back historically, there have been administrative hearings before the DEA before on this particular issue. Those were many, many years ago in the 1980s. That clearly was not an expeditious process. Those hearings took place in 1986. A judge didn't rule on the issue until 1988. And then the DEA did not issue a final order until 1990. So that was actually a 4-year time period between when the hearings took place and when a final order was delivered. Ideally, that is not going to be the case this time. There is much more scrutiny over these hearings than there was back then. And again, there is a request that this be done expeditiously. But again, I would hesitate to try to predict any sort of timeline as to when these hearings will be concluded, or more specifically, when the judge in this case issues a decision and when this final order is printed in the Federal Register. I think we still have to wait and see how that plays out. And I think it's going to be also very interesting to see who the actual parties are that are ultimately accepted to participate in these hearings. In particular, whether these are much of or many of the same parties that were scheduled to participate in the last year's hearings, or if we see a lot of new folks enter the fray and provide expert testimony in these hearings. Adam, anything else you want to add before we kick it
I
back
just
to
wanted to give
Samantha?
the email address. It's mprm@dea.gov. If you want to be an interested person to participate in the hearing, you got to apply before 11:59 on May 24th, 2026. And that is where that is the email address. We did represent in the last hearing an agreed party that was invited to participate. So if anyone has any questions about that, they can reach out to our firm, reach out to Paul. Be more than happy to assist if folks are interested in participating. I don't think I have anything else to add. Paul did a great summary there. I think maybe we made up a little bit of
Quickly
time.
add, someone asked if the hearing will be live streamed. We don't know the answer to that, but the 2025 hearings were supposed to be live streamed. So I would anticipate that these will be as well.
Thanks, Paul. I think we're at time, so we'll hand it back to Samantha to talk about FDA registration.
Thanks, all. So DEA registration. So as a general matter, putting the rescheduling order aside, the CSA obviously requires anybody who manufactures, distributes, or dispenses controlled substances to register with the DEA. And as we all know, to date, state legal medical marijuana entities have largely operated outside of this federal scheme, including with respect to DEA registration, because there was no real pathway for them to comply at a federal level. So now with this rescheduling final rule, DEA effectively defers entirely to the state licensing regimes and provides a pathway for these entities to operate within the federal framework and register with DEA so long as they maintain their state licenses. If you lose your state license, then the DEA registration is automatically suspended. You have to operate entirely within the scope of your relevant state license. DEA defers to that scope and remain in compliance with applicable state laws, including regarding labeling and packaging, disposal, and certification requirements, as we talked about earlier. And the scope of, as I just said, the scope of your DEA registration extends only so far as the scope of your state license extends. You have to pay necessary DEA administrative fees, which I'll talk about in a minute. And we have been referring repeatedly to this closed system. You can only engage in operations with other DEA registered entities. So DEA also clarifies that practically speaking, for medical marijuana dispensaries, they should register with DEA as practitioners, which is the same status that is given to DEA registered traditional pharmacies. The CSA defines dispensing to include delivering controlled substances to the ultimate user, which is what dispensaries are doing. And I also note that registrations are specific to the activities and the substances that are the subject of the registration. They're not blanket registrations to do whatever you want with a particular controlled substance. So in this case, you have to register either as a manufacturer, a distributor, or a dispenser. And then you could, in theory, register for multiple of these things if your activities fall within these categories, but you need to specify that. And as we talked about earlier, entities that apply for registration within 60 days of the publication of the final rule, which I think officially is tomorrow in the Federal Register, you can continue operating consistent with the state license while that application is pending before DEA, and they are endeavoring to process these applications within 6 months. So where does this leave us? Should you register? So when we talk about registration, the pros, I think Sean wanted us to go through the pros and cons of registration. The CSA prohibits manufacturing, distribution, and dispensing of controlled substances except as authorized by law. That's sort of the baseline requirement, and doing so without DEA registration would render these products unlawful and trafficking in controlled substances unlawful. and that could subject you to civil or criminal penalties, injunctions, perhaps seizure actions. So to date, DEA has exercised its enforcement authority and discretion and elected not to go after state licensed operators. But now that there is sort of this structured legal pathway for state licensed medical marijuana operations to fall within the federal framework, DEA may start to take enforcement action against those operators that elect not to register. This is a possibility. And further, you, as a DEA registered establishment, now you have the ability to operate with other registered establishments. And for those who choose to register, the converse being that they cannot operate with establishments that don't elect to register. So perhaps that's the flip side of the same issue. And as Sean mentioned, I believe perhaps that would lead to a structure in which there the DEA registered entities and the people who elect not to, and maybe they'll operate on different levels. So going more towards the cons, I don't remember if anybody mentioned this earlier, but treaty compliance has led to a specific scheme where DEA is the nominal purchaser of these products. And that is currently in place for marijuana. That's for research purposes right now, where DEA purchases these marijuana crops from manufacturers at a nominal price and then sells them back to those entities with the addition of an administrative fee. So as part of this scheme, here in this final rule for state licensed medical marijuana, DEA requires that these crops be stored in facilities to allow DEA to maintain access to them. And so it's possible that entities that handle both adult use and medical marijuana, they would have to separate their crops out in facilities so that DEA can maintain access to only the facility holding the medical marijuana crop. And regarding the administrative fee, I looked this up, and the current administrative fee for this year set for marijuana that's intended for use for research is $113 per kilogram. And the final rule cites to the same regulation for calculating the administrative fee in the context of marijuana used for research at this time. I don't know, it's not clear to me how DEA will calculate this fee now that the program has sort of grown overnight. So the burden of this fee remains to be seen, but that is also a potential con. And you're now formally on DEA's radar if you elect to register, which means perhaps heightened compliance with respect to ensuring that you're in compliance with state requirements, which hopefully you are, and that's not an issue. But now all of these operations that have been sort of flying under the radar might be officially on DEA's map. And again, because I'm an FDA lawyer, sort of on a neutral level, again, I think the registration, whether you elect to register or not, will not impact how FDA views you from an unapproved drug standpoint. So it's unlikely to impact FDA enforcement in that regard. So I will hopefully have made up some more time and kick this back. Oh, not back to you, but hand this to Charlie to talk about 280E.
Okay. Thanks, Em. Charlie Alvasetti here. So I just want to start off before I get into the details I'm going to talk about here is essentially like the impossibility of what I'm about to discuss. There are not definitive answers right now, and we'll talk about why, right? So first off, right, we talked about this potential lawsuit, right? There's regulatory dust that has yet to settle here. Part of that is the litigation. Part of that is the various forms of guidance. We're still waiting on, I'll talk about this in a second, but we're waiting on IRS guidance. There may be further guidance from all these different agencies involved. We don't have that yet, so we can't really say. Part of that is also just, time spent to digest. I know, of course, the second this thing, dropped, everybody and their mother threw it into AI and then put up their summary online. And so, I just want to be a little bit cautious of being so confident in our predictions about how this is going to play out, because there's a lot going on here. I mean, not just like in terms of this order, this DOJ order, but the politics, right, at a higher level. that could impact things, right? I mean, again, we're not dealing with a constitutional amendment, so these things, it's not necessarily carved in stone. These things can shift. So you got to take it in mind. And I mean, of course, if the industry reacts to this in certain ways, you could see politics react to the industry reacting. So this is going to be multi-causal. So the bottom line is take everything, what I'm about to say is sort of my kind of view of like the things I've been thinking about. I don't necessarily have answers for this stuff. And I would just encourage everyone to take everything what I say with a grain of salt, because I don't think we know for sure exactly how this is going to play out. And the last thing I'll say on just the CYA caveat portion is that we exist in a capitalist system, right? And look at other products where there's been a regulatory opportunity to sell something within the confines of federal law. The market will adapt, and life finds a way. And so whatever is ultimately permitted by the federal government, we're going to get more of. So it's going to be a pretty interesting, I don't know, 18 months, who knows how long. I don't even want to say how long it's going to take, but I think you're going to see a ton of adaptations from the industry to whatever guidelines the federal government puts forth. And of course, the other big thing here is, what does this mean for the illicit market? We are in a situation right now where a number of states have sort of tacitly allowed massive illicit markets, even illegal brick and mortar, to just openly regulate. So, what does it mean for the illicit market? Is it going to hurt? I think on some level you could see maybe this cuts down the illicit market if it allows, regulated businesses can be on an open level. But part of that depends on what happens with enforcement. And you always have to be careful when someone says, hey, we're going to make a massive change in law, but we're not going to allocate any money to enforcing it. So, obviously we could take the grain of salt. So first off, I mean, the most meaningful thing here is the 280E piece. So by the way, we've seen, you can look ahead, and what they're going to post tomorrow when the regulations go live, when it goes in the Federal Register, they're going to say this is effective as of the placement in the Federal Register, which contradicts which has already been posted, which is that it was effective upon publication. So it's a little weird. They're going to say, oh, it wasn't effective on April 22nd. It's actually effective, April 28th, but it's still going to be effective. And I don't think it makes a difference from a tax perspective because it's the year in which the announcement's made. But what I'm trying to get at here is like the most important thing is the medical cannabis is moved to Schedule 3. Right, which means that 280E is no longer appropriate for adult use. You're going to have to wait for this hearing. Now, that of course raises a million questions about what happens if you're a dual use business. How do you allocate costs between those two businesses? What if there's only one? What if you're in a state, there's only one license type that allows both adult use and medical? How does that work? So, I mean, the Treasury and IRS has announced a process for tax guidance. So I don't think we have to speculate about any of this stuff. We can kind of see what it says in the guidance. Though, I mean, depending on what the guidance says, I could see people taking different tax positions than what's in the guidance. Obviously, you've seen this to date with 280E. People are taking these positions. They think there's a rational basis to say 280 doesn't apply to their business. Obviously, that's tied into sort of the science here about Schedule 3. So I don't know exactly how tax is going to play out. The other big thing is, a lot of these big companies have massive UTP, uncertain tax positions on their balance sheet. And it's questionable what happens with that. I mean, especially if we saw this order suggest that Treasury strongly consider, going back and reevaluating these past tax liabilities. So that's the tax portion. So 280 goes away for medical, but not for adult use. Of course, if adult use gets rescheduled to Schedule 3 this year, for neither medical nor adult use will be subject to 280E for 2026. So I think we're running a little bit quick on timing here, so I'm just going to go really fast. To me, the most important question here is two big things I want to put in everyone's mind. One is, what does it mean to be federally legal? Federal legality makes a huge difference in the corporate world, because if you can say your business And for a lot of people, by the way, federal legality may just mean the Controlled Substances Act. I mean, that's what we've seen exchanges sort of take a position of historically. So they don't necessarily care about the Food, Drugs, and Cosmetics Act. They care about the Controlled Substances Act because that's where the criminal liability is. But if you are compliant with the Controlled Substances Act, potentially it opens up things like uplisting to US exchanges, which is a dramatic decrease in your cost of capital, institutional investors, right? People that will not invest in these illegal businesses, but would consider it. Payment processing, MasterCard and Visa won't touch these businesses because they're illegal. But again, what if it's a medical business that has an opinion from counsel saying that they're compliant with the Controlled Substances Act? Would Visa work with that kind of person? I mean, is it worth it for Visa or MasterCard to go through the headache of analyzing this stuff? I don't know the answer to that, but I mean, it's a massive change. I mean, people say their store will do 20 to 30% more business if they can accept credit cards. And then institutional buyers, right? At what point does a Fortune 500 company feel comfortable purchasing one of these businesses that's registered with the DEA that's totally federally legal, let's say? Or, maybe it's not compliant with the FFDCA, but it's compliant with the CSA. Is that something a Fortune 500 company might consider buying? What about these deals between Canadian and US companies that allow the Canadian company to purchase US assets upon a change in law? Does this constitute a change in law? Well, what if they divest their adult use assets and only hold their medical assets? Could they then purchase it now? Are you going to start seeing the Canadian MSOs hold medical assets in the US, but not adult use assets? And then, uplist? Are the states going to adjust to, medical? Are they going to expand medical so that the adult use licenses can take advantage of this? And then the last thing I'll say is you got to think about the dormant commerce clause. I've always said that this is sort of like the Deus ex machina no one in the industry really talks about. But if you look at the alcohol industry, you cannot say that in this state you may not sell products grown or produced in another state, right? And this is very well established under constitutional law. So, some courts have not applied the DCD's cannabis because it's federally legal. But with medical, where it's debatable whether federal legalization has occurred for medical, how are courts going to evaluate the dormant commerce clause now? Are they going to say, hey, XYZ state, you can no longer prohibit farms in other states from importing into your state, right? The entire regulatory system might have to be changed because of the dormant commerce clause. I mean, my 2 cents is that states should consider flipping to a 3-tier alcohol model now ahead of DCC challenges, which I realize is a huge undertaking. But I think a 3-tier model would withstand constitutional scrutiny because it doesn't discriminate against out-of-state companies, and it would still allow for a market that's not completely dominated by one monopoly player, which I think is what a lot of people are worried about. So there's a lot there to think about here. I don't have any answers, just things I think you should be paying attention to. And excited to be on the ride with all of you. And I'm going to turn it over to Adam Smith. He's the Deputy Director of the Marijuana Policy Project, one of the most seasoned advocates in the drug policy reform movement. And I know he's been very involved with interstate commerce. So I'll let him take it from here.
Right, thanks so much. You demoted me. I'm the Executive Director of the Marijuana Policy Project, but that's quite all right.
So I'm sorry you had to hear it here.
That's not a problem at all. It pays little enough as Executive Director. I can't afford to step down. So first of all, thank you, Vicente, for inviting me here and for having advocacy as part of this call with Paul here. It's quite important. This is obviously a historic shift, the first time the federal government has recognized medical use in cannabis, and it's something to be celebrated. Having said that, it's an odd order, right? We did not make the cannabis plant Schedule 3. We made it Schedule 3 under certain circumstances and in certain places. If you are a patient in Idaho or Kansas or South Carolina, cannabis is not Schedule 3 for you, and it is not a legal medicine until your state jumps in and sets up a medical cannabis program or regulatory system. And I think that, my job is to talk here about the state markets, and I think that in those states there is a tremendous opportunity and a real need for folks to organize quickly to see about moving medical legislation. Obviously, that's not going to happen in time for new medical cannabis licensees in those states to apply for the DEA grant, and we'll see how that plays out if a state If a state, decides to adopt it, will they get expedited consideration on those applications? We don't know yet. So I think, I wish I could say I had more confidence in how the hearing was going to play out, that the end of that hearing was going to be that cannabis is Schedule 3, period. I hope that that's the case. I like to say hope is my drug of choice, but I wouldn't, bank on it. It feels like they wrote this in a way to really peel off medical as strictly as possible. Given that Todd Blanche is going to choose the judge, we will see how much further the judge goes and the hearings go than what was put into the order. On interstate commerce, I have worked some on interstate commerce in my previous incarnation before I took over last year at MPP. I wrote and led the passage of interstate commerce laws in Oregon, California, and Washington. And those laws all have a trigger mechanism, which says as soon as the DOJ indicates tolerance, the states can regulate trade between legal markets. And so I have no doubt that this triggers those laws. Now, when we passed those, the idea was not to get Oregon, California, and Washington trading amongst themselves. They're all producer states. And so the idea was to get momentum going to push DOJ to issue an opinion or a memo or something like this that would tolerate interstate commerce. I feel like it would be difficult to say, this is Schedule 3, but legal markets cannot bring product in to benefit their patients or allow product to come in to benefit their patients. And in terms of the DCC, the First Circuit has already found that the DCC applies to cannabis. Other circuits have not. But I think that there's a very strong argument under Schedule 3. And I am not a practicing lawyer. I did pass the New York bar, but I haven't practiced. So my medical advice, my legal advice is worth exactly what you're all paying for it here. So I wouldn't, put anything behind it. But my sense is that it would be very difficult to defend state bars on importing product into legal markets from other legal markets. There's not a cannabis exception in the Constitution for the Commerce Clause, and the only things that we regulate in that way are banking and insurance, which are obviously very different. Now, one of the things that's been gnawing at me this weekend, there are a lot of medical states, and there are a lot of operators in those medical states, and I wonder how this changes the incentive for those operators, those people operating in those states, how they change the incentive to push toward adult use. As an advocacy organization, we have been involved. We have led or helped lead 15 state adult use wins and 14 state medical wins. We're involved on both sides, and so we care about medical a lot. But I'm a little concerned that this changes the incentives to push for adult use, and that ultimately is bad for people, for arrest rates. Another alternative is to get states that have medical to drastically expand, the ones that need to drastically expand their eligibility for medical to bring people in. But again, you end up in this political problem where if you are sort of using the medical framework as a way to let everybody in, you sort of open yourself up to charges that we used to get all the time, which is this is not really medical. This is a stalking horse for making it legal for everyone. And that would be true. We want to make it legal for everyone. And so the question is, how do we push forward, especially in places where we may have, large operators that would really, that may decide, I don't know if they've decided or will decide, but could decide that it is in their financial interest and reasonably so to look to expand the medical program and to not want things to go adult use in their states. I think that's something we have to keep an eye on. And so those energies and resources could diverge with the principle of trying to get, cannabis, prohibition to end. And the last thing I will say is that we are doing all this in the shadow of midterms that could very well give us an entirely new Congress by November. And it's unclear what that will look like. And if there is a blue wave and suddenly Democrats are in control of both houses, there's a pretty decent chance that legalizing cannabis will be at least on their agenda. Certainly, they'll have a lot of other stuff to do. And then what will happen between Congress and the White House over the next 2 years to make that happen or not. So this probably raises as many questions as it answers. I wish I could just tell everybody exactly what will be, but that's it. And I think I should stop talking now and hand it over to Q&A.
Thank you, Adam. That was a great segue into a lot of work ahead, and I think this new structure positioned us to really engage meaningfully and with the federal government to have evidence-based responsible frameworks for both medical and adult use cannabis, and we have a lot of law and science on the side to get there, but a lot of logistics to unpack from the rule and a lot of good questions here. One question that I've seen over and over in the chat that I'll ask you, Samantha, is can you explain the logistics of the DEA having to be a purchaser of cannabis? And I understand it's a technical compliance with the rule, and I read it to mean they can be provided access, not necessarily have to be a true party, but could you unpack that a little bit for folks?
I can try. I admit that others may know a lot more about this than I do, but under the single convention requires that the U.S. monopolize the wholesale trade in harvested marijuana. And this regime that DEA has implemented that already exists in the marijuana for research context is how DEA is attempting to comply with these single convention requirements, that it serve as the sole entity participating in the trade of this, which is why it's sort of set up where marijuana manufacturers have to nominally sell their crops to DEA, who then sells it back to them with an associated fee. That is sort of the extent of my understanding of this scheme, how it's implemented in the current status for marijuana research. I'm not entirely sure if it's more complicated than what I just said, or if it's truly just sort of like an administrative transaction of money being exchanged in order to be able to say that DEA at some point had ownership over these crops, in addition to being able to have access to where they are stored and located.
Yeah, no, thank you. That's my understanding as well, and that potentially they could be able to have access without there being
to inspect these
right.
Facilities as well.
Yeah, no, it's a tricky piece, so a lot of good questions on that. And Brian, I'll turn this one to you. What implications do you see for tribal cannabis programs?
Yeah, this is interesting. I was corresponding with some of my friends at the Indigenous Cannabis Association over the weekend, and it seems like treaties were sort of left out here, right? As you have, or tribes were sort of left out, where you have the order specifically saying, state licensed programs will have sort of eligibility for Schedule 3. So, tribal nations were not included. Was that intentional? Was it not intentional? I mean, yet to be unpacked. And these are the things that, we work with a lot of tribal nations, and we're trying to figure out the impact here. Of course, tribal nations typically have a different tax scheme than the rest of the country, so I don't think there's a giant impact of 280E, but certainly things like transport, interstate, intercountry transport, depending on what you want to call it, could really impact the way some of these tribes operate. So again, the things we're unpacking, but could be an exciting development.
Thank you. And another FAQ from the great audience here. The final order also reclassifies FDA-approved cannabis drugs. And Samantha, can you explain what that means, given we already have some cannabis-approved drugs? Could this incentivize some of these states without state medical cannabis programs to look at drug approval pathways? Could we be accelerating drug approval pathways? What is the impact of that?
Yeah, that's a really good question. And my short answer is I don't know what the outlook looks like for FDA-approved drugs that currently contain THC or cannabinoid. The schedules of those drugs have remained unchanged. They are not affected by this order. Drugs that are currently under development are also not affected by this order because they're not FDA-approved drugs, which is what the order reclassifies. For future drugs that will be approved by FDA that contain marijuana, Our read of it is that this order sort of serves as a floor or a ceiling, I don't know which, for scheduling, such that DEA will schedule those approved drugs as Schedule 3, but perhaps they could go to 4 or 5 depending on what the drug is, what its intended use is, and its abuse liability, et cetera. But that it is unlikely that DEA would schedule these drugs in 1 or 2 once they're FDA approved. But I view this more as sort of a theoretical exercise because there is no drug that fits within that bucket at the moment. The focus here is on state licensed medical marijuana. So I guess we'll see. Insofar as drug development, though, that has not changed. The drug development process is incredibly onerous. It's incredibly expensive. It costs a lot of money, it takes a lot of time. It's possible that FDA might develop by policy accelerated approval pathways, or Congress might do so. But as things stand right now, I don't think the drug development pathway is going to get any easier or any harder because of rescheduling.
And I know we're out of time here, but Sam, that just kind of go to my point earlier about like what's the status of the illicit market here. I mean, if from the perspective of like, 'cause, I know this is one thing people talk about is like, oh, does this mean pharma is going to take over, right? From the perspective of big pharma, like, are you going to spend, I don't know, 50 million, $100 million to develop a product, right? Where whether or not you have a patent, the patent's effectively useless because the government won't stop a huge array of illicit actors from selling your product on the street for cheaper than you can because they're not paying taxes or subject to compliance regulations. Like, there would be a pretty novel area for pharma to go into where, historically, why is their industry so profitable? It's because, well, they have like a monopoly on a product that you need to maintain your health, your life, right? Now you're going to go into a market where you have basically the furthest thing from a monopoly, where, people in LA can set up an illegal store and the government's fine with it. So that's why I think like the whole idea that pharma is going to take over, it's an argument that I think collapses almost immediately under any kind of economic analysis, because while I'm sure pharma could take it over if they wanted to, I don't understand why they would have any economic incentive to do so. And yeah.
So teed up a topic for a whole other webinar. A lot to unpack there. And we will have future webinars kind of unpacking in more detail, including anticipated litigation and preparing for the hearing. And I think it's notable, we've had a lot of webinars over the years talking about what federal reform might look like, and now we're talking about executing it. And there's also, so much work to be done in the states and with tribes and for patients. And, another webinar and analysis worth having is patient rights and, what the industry needs to focus on with respect to the record and the hearing coming up. So really appreciate all of the wonderful engagement by the community today and everyone's work to get here. And there's so many great questions in the email. We'll try and respond, but please don't hesitate to reach out to any of us with questions, with feedback. And as we unpack, there will be more to come. Thanks, everyone.
Thank you, everybody.